Hello. Having discussed the role and the expectations for a witness, it would be only logical to continue with the same about the affidavit, the thing which can be used instead of a live testimony, often, sometimes, depending on the court, but still. Affidavit is a useful tool where a person under oath states something. Sometimes it's only, or it's also called the solemn declaration, for example. Sometimes it's only just to attest in some document that this, and this about your child, for example, is true. So it's more or less a bureaucratic formality. But sometimes, especially when it comes to litigation, it can be used instead of a testimony when a person is weak, vulnerable, or maybe you are preparing it in anticipation that the person might not be even alive at the time of the final hearing, with all these long delays that are unfortunately very much characteristic of our legal system. Uh, Sometimes you think that a person who is willing to testify in your favor might, through the years, forget some details, so it's a good idea to collect an affidavit right now and later on use it, and maybe with some explanations or additional remarks in court. But still, this will be like a fresh first-hand information. So, what are the requirements for the affidavit? As you can see, it's pretty much similar to the requirements to a live testimony. It should be still a first-hand knowledge. It should be something that you heard yourself, saw yourself, felt yourself, uh, not something that your neighbor told you that he or she heard from somebody. And again, as in the same way as with a live testimony, if you retell somebody's words, it's only a proof of the fact that those words were said, but not of the facts that those words were describing. So if you say that your neighbor told you that his neighbor stole the bike, it will be only a proof of the words of your neighbor about the bike, but not of the fact that the bike was actually stolen by that person mentioned. So only your first-hand knowledge is knowledge in that sense. It's important because, as opposed to live testimony, when you finalize and sign your affidavit, you have less possibilities, less opportunities to correct yourself later, and it's still a statement under oath, meaning that a question of perjury might be still there. So a written affidavit should be like very specific. When I say specific, I don't mean that it should be categorical in a sense like, yeah, this happened, this didn't. It should be very specific about what you actually can solemnly confirm, basically. Uh, Therefore, remember that memory is a tricky thing, and what you think you remember, some other person who participated in the very same party at the very same day a couple of weeks ago might remember differently, even a color of somebody's dress, for example, and particularly what was said. Uh, Here in Quebec, it's not unusual when a person cannot even remember what language was spoken, English or French, because mostly we understand both. Uh, so we remember the meaning, but not the exact words. And the meaning we remember the way we understood it then, the way we perceived it then, and we might have misheard, might be noisy around and so forth. So why I'm telling you that here, just even if you're sure that something happened in front of your eyes and that you heard something with your own ears, make this adjustment. especially if you're writing in the affidavit. So remember to put it like to the best of my knowledge, to the best of my memory, as far as I remember it now. Because if you don't put it there, and later on it would appear with evidence that something was not exactly as you remember, then everything that you said in the affidavit will be put in question. Is it really? And your good faith even might be put in question. So, however sure you are, make it sure, sorry for the tautology, to cover for a possibility that you made a mistake and that you do not remember something like exactly as it happened. In the same way as in the situation with the live testimony, it's not recommended to try to provide ready conclusions because the decision maker, the arbitrator, the judge, whoever, will not be interested in what's your opinion on that, but what were the facts that led you to that opinion. So if you simply say everybody knows that he's a dishonest person, no, that's empty phrase. It has no value in an affidavit. If you want, you can mention on this date, this person said this to this person just right before me, and later he did or she did this, this, and this, contrary to what he or she said. And this again, and this again, and this again, leaving it to the reader to make a conclusion that that person is not reliable, for example. If you write something like, the goods he or she sells are often of bad quality, again, that's empty. Nobody's interested because it's an opinion, it's a conclusion. Again, there should be particular facts, like this was sold at this price in comparing to this, and this, and that, and that, and that shop. And on this day, I had to go to ask for repairs or to replace, and this again, and this again, and this again. Similarly, something like it might be sold at this price, again, it's your opinion. But if you say that on this, and this date, on the same street in like several like other shops, the same product was sold because you saw it, not because you heard about that, but you saw it with yourself. The same product was sold at this and this price, and it was used this and this way, and so forth and so forth. Then again, the conclusions will be from the facts that you mention. The conclusions will be made by the reader. And it's important again, because when you testify live, and if something that you're saying is not clear, there might be questions for clarification. Even from the bench, the judge might ask, like, what exactly do you mean? Like, can you explain or something? Lawyers can ask also. But if it's an affidavit, either it's so unclear that you will be called to testify live, and then what's the reason for it? Or the reader will simply dismiss those empty phrases because there is no gist, there are no facts, first-hand knowledge, just the foundation. So conclusions, trying to convince, trying to argue, this is all useless in the affidavit. Create a chain of facts which might lead the reader to a certain conclusion, but leave the conclusion to the reader. And relevance. In many affidavits that I have read, at least draft affidavits, there were a lot of attempts to explain like the whole family history, the whole story of relationship, something that would paint that person, again, sorry for the tautology, like personally, individually as a bad one, which has nothing to do with the question. And the more irrelevant is the text in the affidavit, the less serious what is relevant will be taken. Because, well, it would be seen as the person who is telling doesn't know what to tell. So make it shorter, but on the point. Even if you wish to remember, and by the way, when my daughter was a child, he did not give her birthday present when every other neighbor did. Now, when it comes to an issue of a scratch on somebody's car, for example, it's like totally irrelevant. And even if you think that it creates an impression of that person that should explain to the judge or somebody else that this is the pattern, this is the way of living, thinking, and acting of that person, it's only your impression. And in the same way as your opinions and your conclusions and your inferences, uh, it doesn't add anything to the value of the affidavit. Because again, the conclusions are for the reader. The affidavit is a testimony. You have to attest to the facts, not what you think of them, but how you perceived them. For many people, it's quite easy. For some, it's difficult to separate the facts from the perception, the emotional perception, and the context and the whole story and so forth. Therefore, whenever you think that it's important, it's an important document, before submitting, verify it with your lawyer. It will save you a lot of trouble after. Thank you, and have a nice day.